Sacramento, March 2025. They won the appeal and lost the house. The Okafor family did everything the lawyer said. They won the Medicaid hearing. Then an estate recovery lien claimed $214,000. It arrived 8 weeks after the funeral. If your parent is on Medicaid and owns a home, the same lien may already be waiting. The autopsy shows the loss was never in the hearing they won. It was in a form no one read 3 years earlier. In the estate recovery files we've reviewed, the pattern repeats in almost every state. The counsel's note: this is not legal advice. Laws vary by state. Open case file number 001. Daniel Okafor was 74. A stroke took his left side one morning in spring. The rehab discharge planner was gentle but clear. He would not live alone again. His home in Sacramento was small and long paid off. It was worth about $214,000. It was the only thing he had to leave behind. He had willed it to his daughter, Grace. She planned to raise her own children inside it. The family filed for Medicaid to cover the nursing home, and the first surprise landed gently. The home did not count against him. For 2 years, Grace drove to the facility every Sunday. She brought him the newspaper and his reading glasses. Some weeks he knew her, some weeks he did not. The house sat waiting on its quiet street. Grace kept the lawn cut and the porch light on. It was the one promise she could still keep. A primary residence is an exempt asset while the owner is alive. Medicaid does not force a sale to qualify. So Daniel qualified, and the house stayed in the family. Nursing care ran more than $9,000 a month. Medicaid paid it month after month for 2 years. Then the county opened a review of his eligibility. They questioned whether the home should still be exempt. The family hired the lawyer and appealed. At the hearing, they proved Daniel still intended to return home. The exemption held, and the family won. That night, they let themselves believe it was over. "I thought winning meant we were safe," Grace said later. "No one told me the real bill comes after." Daniel died quietly 2 years into his care. By then, Medicaid had paid far more than the house was worth. 8 weeks after the funeral, a letter reached Grace. It was a claim against her father's estate. The amount was $214,000. It was secured by a lien on the house. The state was not asking. It was collecting. Here is the myth the family believed. The house was paid off and exempt, so it was safe. The autopsy shows the opposite. Exempt while alive is the most dangerous kind of safe, because no one plans for the day the exemption ends. And the exemption ends the moment the owner dies. What took the house has a name: Medicaid Estate Recovery. Federal law has required it since 1993. The rule covers anyone 55 or older who received long-term care. It applies to nursing homes and to in-home waiver care alike. The state must try to recover what it paid, not from the living person, from their estate after they die. Every month of care was a quiet loan, a loan against the house written in invisible ink. The bill comes due at the funeral. This is not a rare event. Every state runs a recovery program by federal order. Together, they claw back hundreds of millions of dollars each year. Most of it comes from one asset: the family home. And most families are never warned it is coming. The notice arrives after the funeral when no one can plan. By then, Every good option has already closed. Most families never see the recovery process until it starts. So here is how it actually moves. First, the state files a claim against the estate. Then it records a lien on the home. The heirs cannot sell or refinance around it. They are left with three hard doors. Sell the house and pay the state. Refinance and pay the state in cash, or hand the state the title outright. Grace could afford none of them. The house she meant to raise her children in went up for sale. The notice gave her a short window to respond. An appraiser valued the home for the state. A claims officer, not a judge, set the final number. The buyer's check paid the state first. What little remained covered the realtor and the back taxes. Then the new owners changed the locks. So one question decides everything. What counts as the estate the state can reach? This is where Daniel's case turned. He left the house through a will, and a will must pass through probate. Probate is the one estate every state can reach. For most families, a will simply feels like enough. It names who gets the house, so the matter feels closed. But a will only directs the home. It does not shield it. It guarantees the one path the state always follows: probate. Many families assume any trust fixes that. A revocable living trust avoids probate. In a probate-only state, that can keep the home out of reach. But an expanded estate state reaches it anyway. So what actually stops recovery? An irrevocable trust changes who owns the home. The parent signs the house into the trust and steps off the title. They can keep living there for the rest of their life, but on paper, they no longer own it. When they die, there is no ownership left to recover against. The catch is timing and control. The transfer must happen years before care is needed, and the parent cannot keep the power to undo it. That is the price of the protection. Most families decide too late to pay it. Why do families wait so long? Giving up control of a home is hard while you are still well. The trust feels like a problem for some other year, and that year always feels far away. But the protection only counts if it is old enough. A trust signed the month before the nursing home does almost nothing. The house has to leave the estate long before anyone needs care. Two more moves fail just as quietly. Adding a child to the deed feels safe, but it is a gift, and the gift can be counted. The parent's share often lands back in the estate anyway. Handing the house over outright feels safer still, but a transfer too close to care starts a different clock entirely. Families confuse those two clocks constantly. One clock looks backward at gifts made before applying. It can delay coverage for months. The other clock runs after death and takes the estate. Daniel was caught by the second. The first will open a file all its own, but reach depends entirely on the state. Some states recover only from the probate estate. California narrowed its program to probate only in 2017. There, a home kept out of probate can stay out of reach. Other states use what is called an expanded estate. They reach assets that pass outside probate too: joint accounts, life estates, transfer on death deeds. Ohio, for example, reaches assets that never enter probate. Florida and Texas shield many homes through homestead protection. The same paid-off house survives in one state and is lost in another. The law does protect some families outright. A surviving spouse pauses recovery. So does a child under 21, or one who is blind or disabled. Some states also spare an adult child who lived in and cared for the home. But a pause is not forgiveness. When the spouse dies, the claim can wake back up. We reviewed one home deferred 3 years for a widow. No one paid the state while she lived there. When she passed, the original claim came back in full.
We track these state rules in the pre-autopsy checklist. The link is in the description. haircouncil.com/checklist. Before we close this file, one more thing the county recorder found. The Reyes family lived 2 states away. They thought they had solved this years earlier. They signed a transfer on death deed on the family home. No will, no probate. The house would pass straight to the son. When the mother died, the son felt safe. The deed had worked exactly as written. The home never entered a courtroom. Then the recorder flagged the state's claim. Their state used the expanded estate. It reached the transfer on death property anyway. The lien attached to a house that skipped probate entirely. The instrument was right for the wrong state. The son sold the home to pay the bill. Not every file ends this way. One family we reviewed acted 5 years earlier. They moved the home into an irrevocable trust while the mother was healthy. She gave up ownership, but kept the right to live there for life. When she later needed care, the home was no longer hers to count. When she died, there was nothing in the estate to recover. The house passed to her children, free and clear. It cost them a lawyer's fee and one hard conversation. It saved the house their grandchildren grew up in. The plan cost far less than the loss, but it only works while there is still time to make one. Step back and the pattern is stark. Daniel's house went through a will and the state took it. The Reyes home skipped probate and the state still took it. The third family moved it years ahead and kept it. Same asset, same goal, 3 different endings. The only variable that mattered was when they acted. None of these families were careless. They loved each other and they signed real documents. They simply trusted the wrong instrument or trusted it too late. So the autopsy closes with 3 patterns the surviving families shared. First, the home left the reachable estate while the owner was alive, usually through an irrevocable trust funded early enough to count. Ownership changed before care began, never after. Second, the instrument matched the state's recovery rule. A transfer on death deed protects in a probate-only state. The same deed fails in an expanded estate state. The families learned which rule governed them first. Third, they treated timing as the whole game. Recovery is calculated at death. Nothing signed after the funeral can change it. This is the part most families miss. The appeal win is a trap door. Winning the eligibility fight feels like the finish line. It is the starting gun on the recovery clock. The most common failure in our files is simple. The family wins, exhales, and does nothing. Then the estate pays the bill they thought they escaped. The win was real. The protection was an illusion. If someone you know is planning, send them this case. Next, we open the file on a protection of family set up. One move too late. The file closes here. Yours doesn't have to open the same way.